A phrase that seems to be popping up everywhere in 2025 and which literally did not exist a couple years ago is AI slop. More than a technical nuisance, AI slop, defined as low effort, poor quality, or factually inaccurate content mass produced by generative artificial intelligence models, is a problem for nearly everyone, including in corporate governance. The rapid adoption of generative AI presents Canadian corporate boards with a new challenge: managing the risks associated with AI slop. It can expose organizations to heightened legal scrutiny, reputational damage, and a potential breach of a director's core statutory duties. As AI becomes increasingly material to business operations, a board's failure to address its intended risks, including the proliferation of slop, will make it increasingly difficult to demonstrate the requisite care and diligence of a reasonably prudent person under the Canada Business Corporations Act and its provincial equivalents. Let's start with a definition. AI slop is a pejorative but increasingly recognized term encompassing the low value, often misleading, or poorly integrated outputs of generative AI. You have no doubt run across it in your local media or even news feeds. Common features include content is formulaic, verbose, or repetitive, lacking authentic human insight or value. Generative AI content often creates output that presents false information or hallucinations as fact in a confident, authoritative tone, creating significant liability for accuracy claims. AI-generated decisions or content may perpetuate biases inherited from flawed training data, leading to discriminatory outcomes. And finally, everyone seems to add "now with AI" to their product descriptions these days, suggesting that the capabilities are revolutionary or necessary for efficiency. The deployment of AI, however, often includes features that do not solve a genuine business problem, leading to wasted resources and user annoyance. The pervasive nature of AI slop means its risks are not confined to the IT department. They can touch every facet of corporate liability, from public communications to intellectual property and regulatory compliance. Directors' responsibilities are evolving in the age of AI. Canadian corporate law imposes two overarching duties on directors: the fiduciary duty and the duty of care. The rise of AI, and specifically the risk of AI slop, places significant pressure on both. The duty of care requires directors to exercise the care, diligence, and skill that a reasonably prudent person would exercise in comparable circumstances. This standard is not static, it evolves with the times. For modern Canadian boards, this means a duty to be informed about material risks, and that now unequivocally includes AI. A board which remains ignorant of how generative AI is being used across the organization or the risks posed by its poor quality output will struggle to defend its position under the business judgment rule if a decision results in harm. The business judgment rule is shorthand for the deference courts often grant to boards for their operational and strategic decisions. In brief, if a board makes a reasonable decision in good faith, based on information they should have access to, a court will not normally substitute its decision over the board's. There is more to the business judgment rule, but these are basic factors. At a minimum, directors must ask, what policies govern employee use of external generative AI tools like ChatGPT? How is the accuracy and quality of AI-generated public-facing content, marketing, investor communications, legal documents being verified? What due diligence was conducted on third-party AI vendors to assess the risk of their systems producing AI slop? The board is also ultimately responsible for overseeing the company's risk management strategy. This must now include a systematic framework to identify, assess, and mitigate AI-specific risks. AI slop is a direct result of inadequate technical governance, such as poor training data or deficient quality assurance models. A board's failure to mandate a robust AI risk management framework directly links to a potential breach of the duty of care. The fiduciary duty requires a director to act honestly and in good faith with a view to the best interests of the corporation. The reputational and financial harms caused by AI slop can strike directly at the heart of this duty. If an organization's communications or products are flooded with low-quality, inaccurate, or biased AI slop, it erodes customer, investor, and public trust. This can directly impair the long-term success and best interests of the corporation. The board's oversight must ensure management's pursuit of AI-driven efficiencies does not inadvertently destroy brand value and credibility. The board also has a duty to ensure the corporation complies with all applicable laws. While the Canadian government's proposed Artificial Intelligence and Data Act may be dead, it is almost a certainty we will eventually experience a future of heightened accountability and more regulation. Furthermore, the risk of AI washing, which is misrepresenting a company's AI capabilities or the quality of its AI generated output, is an emerging area of legal and regulatory liability, particularly for public companies. Directors must ensure that public facing communications regarding AI are accurate and verifiable. The failure to govern AI slop proactively transforms what seems like a low level quality control issue into a significant corporate risk portfolio. There are some key corporate risks that are amplified. AI models are often trained on vast, uncompensated data sets, raising significant copyright concerns. AI generated content used by the corporation could infringe on third party IP rights if the generative model was trained on protected works without a clear license. A director's failure to oversee a robust IP clearance process for AI inputs and outputs is a clear governance lapse. The Canadian government's ongoing consultation on updating the Copyright Act to address generative AI underscores the immediacy of this risk. AI slop, which results in an inaccurate recommendation, such as in a product, medical, or financial context, or content that results in biased outcomes, for example, in hiring, lending, or promotional targeting, can create liabilities under consumer protection, human rights, and tort law. The board must verify that AI systems used for material decisions are regularly tested for fairness, reliability, and security. Unauthorized employee use of external generative AI tools often involves submitting proprietary, confidential, or sensitive customer and business data into the public model, risking a massive data breach or loss of trade secrets. Directors must ensure clear policies are in place prohibiting the submission of confidential information into externally provided AI services. To discharge their duties and mitigate the liabilities posed by AI slop, Canadian directors should adopt a proactive, principle-based governance framework. First, build board literacy and strategic oversight. Directors cannot govern what they do not understand. Board education should be conducted and documented to support the defense of informed decision-making. This can include require regular, documented training on AI fundamentals, generative AI capabilities, and associated risks like AI slop. Avoid delegating AI oversight entirely to the IT department. Ensure it is a regular agenda item at the full board or a designated committee, such as risk or governance committees. The board does not need to be technical experts, but they must ask penetrating questions of management, such as what is the acceptable threshold for AI inaccuracy in our public communications? And how do we audit the lineage and quality of our AI training data? The board must require management to establish systematic guardrails to prevent, detect, and remedy AI slop. This might include actions such as the following, which you can pause to read. Make sure to strengthen accountability and documentation. Clear reporting structures and audit trails are essential to demonstrate the reasonable prudence of the board's oversight. Steps to consider are clearly delineate who on the management team, such as the Chief Risk Officer, General Counsel, or Chief Technology Officer, is responsible for AI strategy, implementation, and risk management. Mandate regular detailed reporting from management on AI strategy progress, risk assessments, incident reports related to AI errors or bias, and compliance with internal AI policies. Ensure board meeting minutes clearly reflect the nature of the AI risks discussed, the questions asked by directors, and the board's direction to management. This documentation is crucial for securing the protection of the business judgment rule. The age of artificial intelligence demands a corresponding evolution in corporate governance. For Canadian directors, the threat of AI slop is a tangible indication of a broader systemic risk. By proactively addressing the governance of AI quality through continuous education, mandated risk frameworks, and rigorous accountability, boards can not only shield themselves and the corporation from increasing liability, but also position their organization to leverage the transformative power of AI responsibly and effectively. Reach out to Procido's governance group for guidance in managing this growing part of the business landscape.